Hi, everybody. Today we're going to be reading part 1 of Sigfredo Garcia's motion for post-conviction relief, also known as Sigfredo's terrible, horrible, very bad, no good brief. Let's bring this on the screen, and we'll just try to get through maybe the first 10 to 15 pages. Let's see how long I can keep reading in one sitting. Okay, he filed this pro se. Okay, so hope you guys can see it. Table of contents looks nicely organized. Table of citations. He probably cut and paste this from somebody else's motion. Jurisdiction. This honorable court has jurisdiction under Florida Constitution, Article 5, Section 5.6. Procedural history. Defendant was charged by indictment with first-degree premeditated murder and conspiracy and solicitation to commit murder, consolidation under case number 18 CF 496 by motion of the state for trial. The state also filed intent to seek the death penalty. Defendant was charged with 2 co-defendants, Catherine Magbanlia, there's a typo there, hereinafter KM, who was jointly tried with the defendant, and co-defendant Luis Rivera, hereinafter LR, who pled to a lesser offense of second-degree murder, sentenced to 19 years for a confession, quote, and testimony against the other co-defendants. Rivera's sentence ran concurrent with a federal term, also had pending charges to be sentenced after trial testimony. Okay, seems like there's some words missing there or bad grammar. Defendant proceeded to jury trial, was found guilty, ultimately being sentenced to a life sentence in addition to 30 years, filing a direct appeal in the first DCA case number 1D194005, who issued written opinion and mandate 9/29/21. Defendant filed an ineffective assistance of appellate counsel case number 1D22-2863. Status is pending, filed 5/25/22. No other collateral attacks are filed or pending for this case at this time in state or federal court. Preamble. The defendant, Sigfredo Garcia, hereinafter SG or DIF, period, cites to the court record under RR, trial transcripts, TT, depositions, DP. All others will be cited by name, document, and date. Preliminary statement/argument. In this appeal, SG challenges his judgment of conviction for first-degree murder and conspiracy to commit first-degree murder. He is making that challenge to the best of his ability, although he has been deprived the 1,875 pages record on appeal. This appeal was based off the trial transcripts, TT. Defendant's direct appeal counsel has refused to send the defendant his complete record on appeal. See Garcia v. State, 1D22-2863, 1st DCA 2022. The trial record being a monumental deprivation of rights in a hide-the-ball scheme to prevent specific legal issues raised and argument. The lower tribunal court record is a main artery in a post-conviction context. See Applegate versus Barnett Bank of Tallahassee, 377 Southern 2nd, 1150, Florida Supreme Court, 1979. The appeal cannot make a ruling without a record. See also Lipman versus State, 428 Southern 2nd, 733, Florida 1st, DCA, 1983. Barabee versus State, 771 Southern 2nd, 1263, Florida 2nd, DCA 2000. Hamilton versus State, 573 Southern 2nd, 102, Florida 4th, DCA 1991. Quote, a defendant who has exercised the right to appeal is entitled to a record, unquote. Florida R, or Rule of Appellate Procedure 9.200:9.140B. The deprivation of a complete record on appeal is a state and federal denial of due process being a denial of access to the courts and the right to redress grievances with the government, U.S. Constitution, 1st, 5th, 6th, 14th Amendment rights, and Florida Constitution, Article 1, Section 9, 1621, a party presentation is infringed as without the court record, 3 volumes, 1,875 pages, numerous issues of specific merit and of procedural, fundamental, and possibly structural errors cannot be made. See First DCA 2022, case number 1D22-2863. As such, defendant petitioner intends to invoke the cause and prejudice verbalized in Murray versus Carrier 477 U.S. 478, 485 U.S. 1986, and Florida Criminal Procedure 3.050 exclusable neglect, as issues exist that the defendant/petitioner is unaware of due to a lack of court record through no fault of his own, being outside the scope of his control. Every fact-specific, substantive state and federal issue based of a court record due to hiding the ball. Statement of case and facts. Sigfredo Garcia, SG, defendant, Catherine McBanua, KM, and Luis Rivera, LM, were charged by indictment/information with first-degree premeditated murder, conspiracy, and solicitation to commit murder. The charges stemmed from the July 18, 2014 shooting death of Dan Markell in Tallahassee, Florida. The state noticed this as a death penalty case. SG retained Sam Zangane, Florida Bar number 526721, as defense counsel. Rivera, LR, subsequently agreed to testify for the state against SG and KM in exchange for a 19-year sentence for second-degree murder, running concurrent to a 12-and-a-half-year federal sentence he was already serving for a RICO case in 2015. Over defense counsel's objections, SG and KM cases were consolidated and tried jointly in a joint trial beginning September 26, 2019, the Honorable James C. Hankinson presiding. At trial, the state presented various testimony alleging that one or more members of the Adelson family had hired KM, who hired SG and LR to kill Dan Markell, the ex-husband of Wendy Adelson, over a custody dispute. None of the Adelsons were charged of this. The state's primary witness was/is Luis Rivera, who identified SG as planner and shooter. SG held the state to its burden of proof and did not testify. KM testified denying any involvement, also calling 5 witnesses to attest to this. SG was found guilty of first-degree premeditated murder and conspiracy to commit murder. KM case was declared mistrial when jury was unable to reach a verdict. SG was sentenced to life in prison with 30 years. Death sentence was rejected. SG filed a direct appeal to the first DCA, see Garcia versus State 1D19-4005, and was represented by Baya Harrison, Florida Bar number 099568. In a written opinion, the first DCA affirmed Sigfredo Garcia's, or SG's, convictions on September 29, 2021. SG filed an ineffective assistance of appellate counsel on May 25th, 2022, case number 1D22-2863 with status pending. Standard of review. The right to counsel is the right to effective assistance of counsel. Strickland versus Washington, 466 U.S. 668, 686, 1984, quoting McMahon versus Richardson, 397 U.S. 758, 771 U.S. 1970. The appropriate method to seek post-conviction relief due to ineffective assistance of counsel is that such matter generally should be raised in a motion for post-conviction relief. Kelly versus State, 486, Southern 2nd, 578585, Florida Supreme Court, 1986. In order to prevail on a claim of ineffective assistance of counsel, a defendant must show that the trial counsel's performance was deficient and that the performance prejudiced the defendant so as to deprive the defendant of fair trial. Strickland at 687, Wiggins versus Smith, 539 U.S. 510 U.S. 2003. First, the defendant must establish that the counsel made errors so serious that the counsel was not functioning as the counsel guaranteed by the Sixth Amendment. Strickland at 687, Adry versus State, 659, Southern 2nd, 1069, 1072, Florida Supreme Court, 1995. Second, the reviewing court must determine whether there is a reasonable probability that, quote, but for the deficiency, the result of the proceedings would have been different. State versus Larzalier, 979, Southern 2nd, 195, 203, Florida Supreme Court, 2008. A reasonable probability is a probability sufficient to undermine confidence in the outcome. Strickland at 694. Defendant is entitled to an evidentiary hearing on its post-conviction motion unless 1. The motion filed and record in the case conclusively show that the defendant is not entitled to any relief. 2. The motion or a particular claim is invalid. Phillips versus State, 894, Southern 2nd, 2837, Florida Supreme Court, 2004. In determining whether or not an evidentiary hearing is warranted, this court must accept the defendant's factual allegations to the extent they are not refuted by the record. ID, I guess he means id. Okay, issue 1. Defense counsel was ineffective, failing to file a motion in limine to exclude evidence violating U.S. Constitution 5th, 6th, 14th Amendment rights and Florida Constitution Article 1, Section 916, also ineffective for failing to object to and preserve once presented at trial. The prerequisite to admissibility is authentication. See Bryant versus State. I'll leave out all these citations. The best evidence rule applies when a duplicate or enhanced altered version is offered for evidence at trial. Defense counsel failed to challenge unauthenticated surveillance videos and business records in limine prior to trial. Each will be addressed in turn. A. Surveillance videos. The state entered multiple video exhibits, Premier Fitness exhibits 125, 177. Star Metro City Buses States Exhibits 124, 173, 38 through 44. Still Pictures Metro City Bus States Exhibits 124, 173, 38 through 44. Still Pictures made from Exhibit 124. J.P. Morgan ATM States Exhibit 143. State witness Detective Dietz testified that he altered deleted portions of the videos, completely redigitized them, and put them on a different platform, Premier and Star Metro. Having altered them 5 times prior to trial at the state attorney's direction, the videos being in the government's possession for the last 5 years, TT 223 through 238, line 7. Andrew Brown, Star Metro employee, testified that the 124 exhibit was altered, that the occupants of a Prius could not be seen, and that exhibit 173, offered as a/the original on recall, was actually a copy that was downloaded to a thumb drive from the state attorney's computer. Also stated that the video system at Star Metro only stored video for 30 days. TT 210-222 recalled TT 280 to 284, line 4, 285, line 14 to 25. Len Harvey, Premier Fitness Director, testified that video 125 was altered and that the gym's video system only held videos for 30 days and that the offered original on thumb drive was labeled differently. Moreover, video 177 was/is an unobjected to discovery violation, as defense counsel stated he had never seen it before. TT 629-30, line 16. Counsel failing to object, Florida Rule of Criminal Procedure 3.220, okay, cites to some more cases. This also raised a chain of custody issue that was not objected to, as the offered Star Metro, quote, original was on a, quote, thumb drive that came from the state attorney's computer. And now the Premier Fitness alleged original is also on a, quote, thumb drive. Defense counsel never asked Mr. Harvey where the thumb drive came from. Taplas versus State and Armstrong versus State. Stephen Lutz, J.P. Morgan Regional Security Specialist, testified at trial, the state offering a copy unobjected to. Manolini Supra, that state Mr. Lutz had no personal knowledge of not having sent the video to law enforcement or working at the actual bank it came from, being the regional security for J.P. Morgan, TT 717. Line 20, page 732, line 5, page 720, line 8 through 17, copy. The state also entering exhibits 38 through 44, still pictures off of video, Lerner versus Haligua. Still pictures off of unauthenticated videos are inadmissible. See also Henry versus Zelaya, Wright versus State. Under best evidence rule, in the absence of an original and a exception defined in Evidence Code 90.954 duplicates 90.953, Section 2.3, testimony concerning the original is inadmissible. TDW versus State, Raines versus State, Perez versus State. Quote, a contemporaneous objection is required to preserve error when a eliminate motion is filed. Philip Morris versus French, Horn versus Hudson. Counsel did not object to any video exhibit except once joined an objection with co-defendant's counsel, then withdrew. Counsel must make its own objection when jointly tried. Johnson versus State, U.S. versus Irving. Howard versus Gonzalez, U.S. versus Warfield. Evidence exists that other possible suspects involved were ignored and leads not followed. TT 2638, line 24 through page 2647, line 9. State Attorney Jason Hewlin, TT 2381, line 12, Special Agent P. Sanford, FBI Detective Dietz, stated he was taking orders from State Attorney in his alterations. And Detective Isom, retired Tallahassee Police Department homicide, TT page 403 through 407, line 1, testified that he could not say what occurred in the missing video, quote, premiere minutes, and said nothing was deleted, and he saw the original videos, TT 353, line 321. Clearly from the testimony of Detective Dietz that is not true, quote, missing minutes. Detective Isom speaks about the fact that he cannot tell what happened in the missing minute of the video. Defendant contends that it is possible that the missing minute altered and, quote, deleted portions show somebody other than the defendant, unquote. The bias agenda of law enforcement being a fact of record. The prosecution even asked the retired detective Isom if anybody in the prosecution team as a whole, including himself, coerced a fabricated, quote, spoofed story to the confessing co-defendant LR, TT 487, line 22 through page 488, line 8, Rodriguez versus State. The question also amounted to the state attorney testifying through witness testimonial answers generated specific question, Becker v. State, Hutchinson versus State, placing the prestige of the government behind the witness, LR confession. The defense failed to move for a mistrial or curative measure, West versus State, Mabry versus State. Multiple prejudices occurred as a result of counsel failing to exclude these unauthorized videos, bad faith having been shown on the part of law enforcement, and a genuine dispute exists concerning the originals. The prejudice extending to state witness LR confessor, who testified about all videos, TT 848, line 5, 853, line 2 through 11, page 854, line 10 through page 855, line 7, quite possibly, more likely than not, told what to say. See Defense Exhibit 6, the state relying on the videos in closing. TT 3024, placing the defendant around / at the scene of the crime with a confessing co-defendant. Bartholomew versus State, quote, courts may look to if the state relied on the error in final argument. TT 3012, line 15 to 23, ATM video. Okay. So that's just the first 10 pages of this brief. The whole thing is about 46 pages, so we'll just see if there's much of an interest in even looking at this type of video, and hope you guys are doing well out there. We'll have some sort of live open discussion live stream in the near future. Thank you for your interest in this case, and see you at the next show.